You're good to go, Scott.
Okay. So good morning, everybody. Thank you for joining us. And again, sorry for the technical difficulties, but we are up and running. My name is Scott Cruz. I am a labor and employment attorney for the law firm of UB Greensfelder. I practice out of our Chicago, our O'Fallon, Illinois, and our St. Louis, Missouri offices. Have been practicing employment law on behalf of employers since 2002, so for a long time. And my day encompasses what we're going to do for the next 2 hours, and that is making sure employers are up to date and know about the current state of the law. And so today, there's going to be essentially two parts of this webinar. The first part of the agenda, we're going to take the crystal ball. We're going to look 13 days or 14 days in our future come January 2026, and we're going to see what's in store for us. And then the second part of the webinar is we're going to take the crystal ball away. We're going to look in our rear view mirror all the way back to January 2025 to see what's been going on over the past year. If we were doing this in person, I'd hope I wouldn't get a deer in headlights look from any of you when we talk about any of those laws, because they've been in place going now a year already. So hopefully that will be a refresher for all of you. I will take questions at the end. There should be a function where you could, I'm not going to check it while I'm presenting, but at the end, certainly I could answer any questions you may have. So let's wait until the end. But with that, let's get started. So legal disclaimer here, nothing that I'm saying today should be construed as being legal advice. This is only a mere summary of what the new and amended laws are for each and every one of you. Okay, so we've got the crystal ball. Let's look ahead to January 2026. What do we have in store for us? First, the Illinois Human Rights Act, that is Illinois' version of, let's say, Title VII, the ADEA, the ADA, all of the federal employment laws here in Illinois. We have an act called the Illinois Human Rights Act, and we've got that codified into one act, and so that's what the Illinois Human Rights Act is. The Illinois Human Rights Act is going to be, has been, and those amendments will take effect January 1, 2026. And the genesis of the amendment is that the amendments will prohibit employers, to the extent you are using artificial intelligence, in other words, AI, in any aspect of making any employment decisions. So, for example, are you using AI currently to assist you in recruiting? Maybe doing resume screening, or while you're actually interviewing someone? Are you using AI in making any employment decisions for your current employees to determine whom, for example, should get a promotion? If you are, then this amendment applies to you, and make sure you understand, and which you will, what is going to be required of you. So how is the amendment defining AI? In other words, artificial intelligence. It means a machine-based system that, and this definition comes straight from the Illinois Human Rights Act. It's not me making it up. A machine-based system that, for explicit or implicit objectives, infers on the input it receives, right? So there's an algorithm, it gets information that's inputted, and then from that information that's inputted, it generates outputs, right? Such as predictions, content, recommendations that we as employers may use in influencing the decisions we make, the employment decisions that we make, right? So for example, let's say you have are using AI as a resume screener, right? And let's say the algorithm or the input used generates outputs that, for example, say if anyone lives in X area code, they are more likely than not to be of this particular race or this national origin. That's a big no-no, right? If in fact your AI is generating those types of outcomes, and you are using those outcomes in making decisions as to should we make an offer of employment to Anna, who's applying for the position of, well, it looks like Anna lives in this zip code. We haven't seen her, right? We're just looking at based on what's in her resume, and it looks like, at least from our AI, from the outcome that it's generating, she's probably of this race. Oh yeah, no, we don't want people of that race in our work environment. That's a big no. That is a big uppercase NO. And the concern here with AI is that when it makes those types of decisions, there is a disparate impact on protected classes. And what's disparate impact mean? That's just a fancy legal word that lawyers use that says that an employment decision affects a big group of people, right? So using my example, that generated output, right, that says that people who live in this area code are more likely than not to be of this protected class. Well, that has a disparate impact on individuals living in that area code, because it assumes or implies that they are of a particular protected class. And we're using that to make employment decisions that affect potentially that protected class. And that, my friends, is what we call discrimination. So again, here's the example I've been using, right, where it's not just zip codes, but for example, the algorithm or the input that your AI system or platform is using may generate an output. Again, this is for, we haven't seen the person yet, right? We're just looking at, and I'm making that for ease of purpose of this hypothetical. We haven't seen the person. All we have is a resume in front of us, right? And so the AI output may generate and say, well, people with this last name or this educational background, if they don't have a high school, college diploma, they're more likely than not to be of in the blank, a particular protected class. We make sure everybody's muted. And so this AI, the amendment to the Illinois Human Rights Association, one person hasn't muted themselves. I'm seeing them on the screen right now. It will prohibit us from making those types of decisions, right? From using AI in that fashion, if our AI platform is in fact generating those types of decisions. So what do, right? We need to conduct regular audits of our AI systems to identify and address the potential biases, right? So what do? We talk to our vendors, right, and say, hey, you sold us this particular platform, this AI system. Have you yourself, vendor, right, conducted any type of audits to make sure that what you sold us, right, or the algorithm or the input that's being, the information that's being inputted is not going to generate an outcome that's going to have a disparate impact on individuals of a protected class? That should be a fairly easy question for any vendor to answer. And if their answer is we have not, that should be problematic. And that is problematic because they need to do so. So again, this applies only if you are using AI in making employment related decisions. This amendment will require us to provide notice to any applicants and or current employees that we are using AI in employment decisions. Now, I have in front of me, that has not been released to the public yet, but fortunately, you have someone giving a webinar who's got all the inside scoop of the draft rules that the Illinois Department of Human Rights is considering putting into effect, finalizing. And these draft rules give us guidance. I always like to think of rules as the meat to the bones being the law, the rules are the meat to those bones. And the rules give us insight into how we should be interpreting and applying the particular provisions of any act. And so these rules state that, give us guidance as to, again, they're proposed, so nothing's finalized yet. That's why I haven't put them in the slides yet, because they're still subject to change. But they do give us guidance on when we're supposed and how we're supposed to give notice, right? So the rules state that we have to provide notice, again, subject to change, in any employee handbooks or policies in any conspicuous location or physical premises in our facility. If we have an internal intranet or an extranet or on a web page, we have to put that notice. And of course, the question you're asking is, Scott, well, what's that notice supposed to say? And what the Illinois Department of Human Rights, at least as of right now, again, these rules have not been finalized, they're draft, but it says in here that the information in the notice is supposed to be the following: the product name and developer of the vendor of the artificial intelligence system. So that's why I said, that having that conversation with your vendor is important, because their name is going to be in the notice that we are required to provide to our applicants and our employees. Which covered employment decisions the artificial intelligence system is going to be influencing. In other words, are using it just for recruiting, right? So then only applicants or even current employees, to the extent we're talking about job postings, right? Internal job postings. The purpose of the artificial intelligence system, including the categories of personal information or employee data collected or processed for the system. The types of job positions the AI will be used for, right? Only applicants, only non-exempt hourly positions, salaried exempt positions, right? However you're using it. A point of contact. If there are questions, who should the applicant or the employee reach out to? Is someone in HR, the hiring manager? The right to request a reasonable accommodation and instructions how to do so. And then specific language from the Illinois Human Rights Act. So once those rules are finalized, which once they are, and it likely will happen hopefully by the end of the year, the Illinois Department of Human Rights will issue those on its webpage. If you are using AI, make sure that you read and understand those rules. Those rules are going to fill in the blanks for a lot of questions, particularly on this notice, in terms of what we have to do. All right. New law that goes into effect June 1st, 2026, not January, June 1st, 2026. So it applies to Illinois employers if you have anywhere from 16 and over employees, right? So if currently right now you only have 13 employees, this act doesn't apply to you. But if you have 16 or more, it does. And if you have, let's say, between 16 and 50 employees, then this act, when it goes into effect on June 1st, 2026, it requires us to permit our employees, to use a maximum of 10 days of unpaid leave, or the length of time the employee's child is a patient in the NICU, whichever is less. If you have between 51 or more employees, then we have to permit employees to use a maximum of 20 days of unpaid leave, or the length of time the employee's child's patient is in the NICU, or whichever is less. Employer, I don't know who's on this webinar, but I'm going to assume that all of you meet this definition of employer. Child is a definition similar for those of you who are subject to FMLA. You're going to see this definition, or you're all, based on where you're located, subject to the Paid Leave for All Workers Act, similar definition to whom a child is. A child's a son or daughter, biological, adopted, foster child, stepchild, legal ward, or child of a person standing in loco parentis. In loco parentis is another fancy legal word that lawyers use. That, for example, would be, let's say that when I was born, my mom passed away during birth, and I don't know who my dad is. And grandma raised me. Grandma would be considered my in loco parentis parent for purposes of this definition, right? And so that would apply to the extent grandma comes to you and says, I need to take leave because my daughter passed away while giving birth. I am the only person, the adult for this child. Child's in the NICU. Grandma would get it. Then NSAU, there's the definition there of what that is. So this act is kind of an anomaly in the sense that when we see different leave laws in Illinois, let's say, for example, VESA, which all of you are subject to, the Victims Economic Safety and Security Act, that entitles employees to a certain type of unpaid leave. Generally speaking, when those laws implicate bases on which employees can also take FMLA leave, for those of you subject to FMLA, those two laws will run concurrently. In other words, for example, if I take leave under VESA and it's a reason also I take a leave under FMLA, both those leaves are going to happen at the same time, right? So VESA will run concurrently with FMLA. And once I'm done with FMLA, I'm not going to get additional time under VESA because they run concurrently. This Family Neonatal Intensive Care Leave Act is different in the sense that the reason to the extent you are subject to FMLA, an employee will, of course, be eligible for FMLA, get the basis to care for an immediate family member, right? So they're going to get FMLA. But under this law, once FMLA expires, even though hypothetically the two are running concurrently, once FMLA expires, that employee will get the amount of leave that the act requires us to permit the employee to get. This does not extend FMLA. FMLA ends continuous 12 weeks. It ends. So, for example, let's say little Johnny's in the NICU. I request leave under FMLA. You're going to give me that leave because I'm eligible for it. I take the full 12 weeks. And after the 12 weeks FMLA ends, let's say, I'm an employer that has 100 employees, I will still be entitled to 20 days of unpaid leave, not under FMLA because FMLA expired, but under this act, right? So it's important for you to understand that while these two generally run concurrently, if FMLA ends and the employee still needs time because little Johnny's still in the NICU, then however much time, based on how many employees you have, that employee is entitled to under the act. They get it. Much like FMLA, leave under this act may be taken continually or intermittently, right? Continually just means without any breaks, right? So it's 20 days continuous. Or intermittently means a certain day, a couple of days a week, couple of hours a week. If the employee opts to take it intermittently, then we can require that they take it in no less than 2 hours of duration. So if the employee says, well, I only need it for 1 hour, your policy can be written in such a way that says, well, our policy says you've got to take it in 2 hour increments. So we understand you only need it in one, but our policy says you have to take it in two if you choose to implement that. We cannot require that employees first use and exhaust any company-provided paid leave. Now, let me peel back the layers of that onion. Let's assume you are subject to FMLA, right? Well, that's different here because I'm going to assume and hopefully your FMLA policy says and requires employees to use company-provided paid leave while they're using FMLA, right? So you need to make that distinction, right? That because, again, I'm going to be eligible for both, right? Assuming you're subject to FMLA and I'm eligible for FMLA, right? The reason Johnny's in the NICU is going to apply to both. So you can require me to use company-provided paid leave under your FMLA policy, and you need to make that very clear, right? And then they'll use it that way. But let's assume, for example, that you are not subject to FMLA, so you have no idea what I'm talking about requiring employees to use paid leave concurrently. Let's say you have 30 employees, so you're not subject to FMLA. Right? If that's the case, you cannot say, well, Scott, you've got 80 hours of paid leave, right? So for the entirety of the 10 days you're asking, you have to simultaneously use those 10 days. Cannot do that. Cannot do that under this act. Now, the employee may voluntarily request it, right? Because it is unpaid leave, but you as the employer cannot mandate that. Again, so there's the distinction of, are we subject to FMLA? What does their FMLA leave policy states? And then those of you who are not subject to FMLA. Employees may not suffer any loss or benefits held or accrued prior to taking the leave, right? So if I'm taking 20 days, you can't say, well, 20 days you're not going to have health insurance, right? Any benefits or leave that I held or accrued prior to taking the leave, they must continue during this leave period. Leave is job protected, so think FMLA here. And for those of you not subject to FMLA, job protected just means when I'm done with my leave, right? So let's say it's the 10 days, because assuming you don't have that subject to FMLA, you must reinstate me in the same or substantially similar job position, that I was in when I come back, right? So if I was a forklift driver making $30 an hour when I started to leave, in 10 days when I come back, I'm going to be put right back in that forklift driver position making $30 an hour. You can require that the employee provide you with reasonable verification of little Johnny's length of stay. That is all you need. That is all you should be asking for, right? We do not care, nor should you, of any, and do not request any confidential medical information related to little Johnny and why little Johnny's in the NICU. All you can require, and all you should be requiring, to the extent you do, is how long little Johnny was in the NICU. If you don't comply with this law, you're subject to a civil penalty of up to $5,000 per violation. All right. Organ donor leave. So this is not a new law. This is an existing law this is an amendment to an existing law. The existing law is the Blood and Organ Donation Leave Act. For those of you who have less than 51 employees, you may be saying to yourself, I've never heard of this law. And the reason is because you're not subject to it. But if you have 51 or more employees, you are subject and always have been subject to this law. And so the amendment amends this act. And it's a very narrowly focused amendment, and it's limited in scope. So under the Blood and Organ Donation Leave Act, it's kind of two parts to it. The first is dealing with donating blood, and what it says, and that's not being amended, but I'm just giving this to you for context purpose and edification, right? That employee may use up to 1 hour, I think each 56 days, you get 1 hour of paid leave each 56 days to donate blood. That is not changing, and that relates only to full-time employees. The second part of it, which it is being amended, is as it relates to an employee who wants to be a good human and donate an organ. And right now, as of December 17th, that applies only to full-time employees. Come January 1st, 2026, except you have part-time employees, and they also want to be a good human and serve as an organ donor, they will get paid leave just like your full-time employees do. So the amendment states that any part-time employees may use up to 10 days of paid leave in any 12-month period to serve as an organ donor. Right now, the law just states it's only for full-time employees. Come January 1, part-time employees. Now, you may be asking yourself, well, Scott, how does the act define part-time employees? It doesn't. So my question to you, and it's not a rhetorical one, how are you defining part-time employees in your employee handbook? That's going to be the definition of a part-time employee. So the definition of a part-time employee is, what's your definition of a part-time employee? How are you defining part-time employees in your organization right now? This paid leave, very important. It is not paid leave that we're required to give the employees under the Paid Leave for All Workers Act. This is separate and apart from that paid leave, right? So you cannot say, Scott, sure, we applaud you. You want to be a good human. You want to go be an organ donor. You've got 80 hours of paid leave under the Paid Leave for All Workers Act that we have, we're required, not necessarily required, but you have. You're required to use and exhaust those 10 days of paid leave that we provide you. You would be in violation of this act. It is paid leave separate and apart from that. So you are paying me to be a good human and serve as an organ donor. And I am not taking or utilizing any paid leave, commonly provided paid leave, that's already existing. How do you determine how much you're paying the part-time employee, right? Because many part-time employees, right, their hours fluctuate. And so what the act says is that we're required to calculate the daily average pay that the employee received during the 2 months worked prior to the commencement of the leave. So let's say, for example, right, that I tell you, hey, I'm going to be a good human and be an organ donor on March 1st. You're going to look at January and February to get the daily average pay that I received in those 2 months. And you're going to compensate me based on that daily average pay that I received in those 2 months, right, for any days that I'm out while serving as an organ donor. You can require, just like you can of your full-time employees right now, your part-time employees to provide with supporting documentation that they're in fact going to be an organ donor. And you can require, and you should have this written in your policies right now for full-time employees, that they can't just do this, right? They need to get approval from us first, right? So, how much time do you need in advance? All those things should be laid out in your current policies. Okay. If you can make sure you're muted. Next amendment I want to talk about goes into effect January 1, 2026. It's an amendment to an existing law, the Victims Economic Security and Safety Act. We, all of you, I don't need to know who's on this webinar, every single employer in Illinois, if you have 1 or more employees or just 10, you are subject to VESA. VESA is the acronym, by the way. So what does this amendment, what does the amendment do? Well, what's the scope of it? So again, very narrow in terms of what the scope and application of this amendment is. But it addresses employees' personal use of employer-provided electronic devices. So for purposes of the hypothetical, let's assume we're talking about the iPhones that, that let's say that you give iPhones to your employees, right? Again, whether you do or not, I don't know. I'm just giving you a hypothetical. And the concern with many employers that they have, and you may have policies that state this right now, is that, you may say, if we give you a work, iPhone or whatever cell phone, that you must restrict use of that to only business-related matters and cannot use it for personal matters. Now, that type of overbroad policy candidly likely is in violation of the National Labor Relations Act, so hopefully you don't have that. But let's assume you've not retained me to look over your employee handbook, so I didn't point that out to you yet. But this amendment says that we must, to the extent, let's say, for example, again, we give cell phones to our employees. We must, as employers, permit employees to use those cell phones to record domestic violence, sexual violence, gender violence, or any other crime of violence against the employee or a family member or a household member of the employee. In other words, we must permit employees to use employer-provided electronic devices for the same reasons that the employee can take leave under VESA. These reasons here for domestic, sexual, gender, any other crime of violence against the employee, that's why the employee can take VESA. And so what the amendment does, it prohibits us from saying, hey, Scott, we learned that you used your company-provided cell phone to record your spouse assaulting you. And that's a big no-no. I mean, did you not read the employee handbook? So not only are we going to take that cell phone away from you, we're going to discipline you for that. Come January 1, 2026, you'd be in big trouble if you did that. It also requires us to grant employees access to any photographs, voice or video recordings, sound recordings, or any other digital documents or communications stored on the employer-issued device. So again, let's assume for purpose of the hypothetical that it's a cell phone. Now, what is the concern here that I have that I'm going to share with you, and then we'll talk about how we deal with that. The concern that I have for you and my clients is, well, when I leave, right, what happens? You require that I give you that cell phone back, right? And this law, this amendment says, well, we must permit employees access to any photographs, voice, or video recordings, or anything they have on there relating to, any type of VESA permitted basis. Well, how are you going to know that? right? It's unlikely the employee is going to share that information from you, which means what? Which means that when you get the cell phone back, you're probably not going to know. And whatever your policy states in terms of when you wipe it clean, maybe some of you have policies, internal control policies that state when we get the cell phones back, we wipe them clean within 24 hours. Well, that's not going to be good, right? What happens if the employee comes back to you 2 weeks later and says, employer, sorry about that. I forgot to tell you, right, that I have stuff on this cell phone that I need. So can you give me my cell phone back? And you're going to say, well, we wiped it clean, within 24 hours. So now all of that information's gone. Uh-oh, right? Uh-oh for you as the employer. So how do we handle that? Well, just like with anything, right? We create and draft policies, written policies, because I know all of you have employee handbooks, right? All of you shake your heads. I can't see you shaking your heads, but I know all of you are. And in your employee handbooks, I know all of you have a VESA policy, right? Shake your heads. I know all of you, to the extent you have employer-provided devices, have a policy documenting use on employer-provided devices, right? Shake your heads. So we create policies under VESA and under those employer-provided device policies that state something to the effect of, to the extent you were given access to an employer-provided device, and to the extent you use that employer-provided device for any permissible basis under the Victims Economic Safety and Security Act, to record domestic violence, sexual violence, gender violence, any other crime of violence committed against you with a family member, prior to separation of employment for any reason, you're required to notify the employer, right, to notify the company that such information has been recorded and is on that cell phone device. The employer will, in that case, keep such information available for a period of, and this is where it gets a little gray area because the Illinois Department of Labor has not said, well, how long we got to keep it. But I think it's important to say, hey, we'll keep it open for, we won't wipe that phone clean for, let's say, a month, which I think is more than enough time, right? Because at the end of the day, once we're on notice of that, we can at that time say, you know what, we're going to download that information and we're going to send it to you, right? And so you want to have those types of policies in place. So then when the employee comes back and says, hey, after, 3 months later, and we say, hey, you got the policy. You knew that you had to let us know. You didn't. And in fact, we had a runway for you that said, let us know within a month. You didn't. So we don't have it available to us anymore. Right? Now, is that going to immunize us? I don't know. I'm not the Illinois Department of Labor. I hope it would. I think, as a lawyer, I can make a very good faith argument on your behalf and say, Department of Labor, we put these policies in place. The employer, and here's the signed acknowledgement we have from the employee. They said not only they received it, they read and understood it, right? And they knew at the time of separation, they were supposed to let us know. They didn't, right? Now, what you could also do if you want to be safe, at the time of separation for anybody who has an employer-provided device, say, is there anything on this cell phone that you may need moving forward? Right? Document the answer to that. So then you have something else to show the Department of Labor if they come knocking on your door. Right? So, policies matter. Properly drafted policies matter even more. Right? So again, with something like this where I can see this, that potentially happening, you want to make sure you have the right policies in place. All right. An amendment to an existing law that, quite frankly, I'm unsure why it was needed because in my opinion, this has always been the case. But there's an amendment to the Nursing Mothers in the Workplace Act, which I know all of you have in your employee handbooks. The amendment goes into effect January 1, 2026. But from my perspective, this has always been the case. And in fact, has been the case here in Illinois since as early as 2017. But now it's in bright light. So there should be no confusion. But the amendment says that we must compensate mom, which hopefully you've always been doing, for any break time that mom uses to express breast milk for up to 1 year after the child's birth at mom's regular rate of pay. Now, again, in my opinion, this has always been the case, at least since 2017. I've drafted all handbook policies to state that we're required to compensate mom for this, and you should have been. But now, like I said, now it's in bright lights. So if you weren't doing so before, make sure your policies have been amended, at least prior to January 1, 2026. We can now require mom to use paid leave during that break time because this is, time we're compensating mom for. And again, this is not new. This is always in the act and has not changed. We have to provide this reasonable break time as needed by mom, unless doing so creates an undue hardship for us as an employer. I would be very careful if you're going to take that exception and say, yeah, it's going to create an undue hardship. Because what I've seen over the past several months is many employers have been getting sued based on their claim that's an undue hardship to accommodate mom for this purpose. So if you're taking that position, understand that it's probably not a tenable position unless it is truly an undue hardship for you. All right. Another amendment to an existing law here in Illinois that takes effect January 1, 2026. The law is called the Workplace Transparency Act. This law has been on the books since January 1, 2020. And if you recall, for those of you who remember and are aware of this law, this act, it was enacted during the Me Too era. And it was enacted during the Me Too era to protect employees, consultants, and contractors who truthfully report alleged discrimination or harassment in the workplace. And it prohibits us as employers, or more importantly, lawyers who draft confidentiality provisions on behalf of employers, from creating this general and very broad confidentiality provision that says anything that you learn in the workplace is confidential. Because the reason we did that is to ensure that when employees leave, they're not airing our dirty laundry, right? So, the employee may think that they learned about what a bad employer we are, and that, it is just a toxic work environment. And I heard that there were all these rumors of sexual harassment going on part of January 1, 2026. When I created these types of provisions for my clients, that was included in there. And now it's not. Now employees have the right to, in essence, air the dirty laundry that they think they know about us, and we cannot, via contract or otherwise, really stop them from doing so, with some exceptions. So what are the amendments? So the First Amendment is, and think of it in terms of, again, the confidentiality provisions, right? They're always broadly drafted, and we draft them as lawyers broadly for a reason, because we want to make sure it encompasses a lot of things. And so right now, the Workplace Transparency Act says that it prohibits any contract, any agreement, any clause, covenant, waiver, or other document. Another document means, your employee handbook, from prohibiting, preventing, or otherwise restricting a current or former employee or an applicant from reporting allegations of unlawful conduct to federal, state, or local officials for investigation, including but not limited to criminal conduct or unlawful employment practices. So the first part of the amendment expands this definition of what constitutes an unlawful employment practice, right? In other words, what employees can rat on us for. And right now, and so what I did here for you is what's in red on the screen, that's what's new. And what I've crossed out, that's what's going to be gone come January 1st, 2026. And in essence, this definition of unlawful employment practice has now been expanded to include a lot more, right? So what it's going to mean as of January 1, 2026 is that an unlawful employment practice, in other words, what an employee can tell on us about, means any practice made unlawful that is actionable under the Human Rights Act, Illinois Human Rights Act that is actionable under Title VII or any other state or federal rule of law governing employment, including those enforced by the Illinois Department of Human Rights, but also now any laws that are enforced by the Illinois Department of Labor, the EEOC, which was always there, any laws enforced by the U.S. Department of Labor, the Occupational Safety and Health Administration, so OSHA, and the National Labor Relations Board, i.e. the National Labor Relations Act. So what it means now is that any unlawful employment practice covers, for example, any wage and hour violations that an employee thinks occurred, any workplace safety concerns, i.e. OSHA, and any unfair labor practices, right, that could get us in trouble under the National Labor Relations Act. Now, this was a big waste of time, in my opinion, because we never could stop employees from disclosing these things. The Fair Labor Standards Act, FLSA, we'd be in big trouble if we tried to get an employee to say, hey, you cannot disclose what you believe the wage and hour violations. OSHA has similar provisions that prohibits us from trying to prevent an employee from ratting on us on any workplace safety concerns. And certainly the National Labor Relations Act permits an employee to tell on us for any unfair labor practices. So, this was an overkill in terms of here in Illinois, that we didn't need it because it was already codified under federal law, but now we have it here in Illinois as well. It also, next part of the amendment, not next part, but another aspect of the amendment is it prohibits us, and again, in my opinion, as you'll see, 100% unnecessary, but it is what it is. It prohibits us from including in any contract agreement, clause, covenant, waiver, or other document from prohibiting employees or restricting them from engaging in concerted activity to address work-related issues. Well, you may be saying to yourself, where have I heard of this phrase, concerted activity? And if you answered the National Labor Relations Act, you'd be right. Again, the National Labor Relations Act prohibits employers from preventing, restricting, or otherwise intimidating employees from engaging in concerted protected activity to address work-related issues. So this was already codified law under the National Labor Relations Act. And guess what? You are all subject to the National Labor Relations Act. But now it's codified under the Illinois Workplace Transparency Act. So when I bring up other document, why did I highlight that? Why did I put that in bold? I put that in bold is because many of your handbook provisions are probably landmines that you're not even aware of, unless you had me review your handbook and I would have spotted this and changed it for you. But with now this amendment here under the Illinois Workplace Transparency Act, and certainly always being codified in the National Labor Relations Act, what provisions in our employee handbook should we be reviewing and potentially modifying to make sure there is no implication that we are prohibiting, preventing, otherwise restricting individuals from engaging in concerted activity to address work-related issues? All right, well, here's a few of them. Do you have a duty of loyalty provision in your employee handbook, right, that says, hey, don't do anything that could be a conflict of interest? Well, if an employees decide to form and join a union, well, that's going to be a big conflict of interest because I'm not sure I know one employer that says, yeah, we want a union. Well, we welcome them with open arms. No, we don't want unions for any reason whatsoever, right? So how does your duty of loyalty provision phrase? What does it say? Is there any implication there, right, that it could in fact trigger or otherwise think an employee can say, hey, I may violate this duty of loyalty provision if we try to join a union here? Solicitation and distribution, right? Are you permitting mom and dad to solicit during working hours for Boy Scout, Girl Scout cookies, which I know now is the season, or little Johnny's in Little League and they're doing some fundraiser? But then, for example, we say, oh, but if you're looking to hand out material or ask people to join a union during working, no, can't do that. Again, that's a violation here. If you're doing it for one, you got to let people do it for everybody. Personal cell phone policies, What does your personal cell phone policy say? Does it state, for example, again, for those of you who give cell phones to your employees, does it state that you cannot use personal cell phones during working time? Well, that certainly sounds reasonable, right? I mean, we don't want employees on their personal cell phone during working time because we're paying them to work. Well, the National Labor Relations Act, and now the amendment to the Illinois Workplace Transparency Act is going to say, well, hold on a second, employer. So what if, for example, employer, that the employee sees you committing an unfair labor practice, sees you committing an OSHA violation, and the employee uses the cell phone during working hours to tell on you? The employee is going to think that they can't do so. And guess what? They have to be able to do so during working hours in real time, right? So that policy violates the National Labor Relations Act. Certainly now is going to violate the amendment to the Workplace Transparency Act. So what we need to do in those types of provisions, and again, without looking at any of your provisions, but I have a general sense of what they say, is something to the effect of, notwithstanding the above, the employees are always permitted. The provisions above do not prevent, restrict, or otherwise, prohibit employees from engaging in any protected concerted activity, protected under the National Labor Relations Act, and or the Illinois Workplace Transparency Act. I have a much more broader provision, but something to that effect here, so we can say, hey, we had a carve out, so the employee shouldn't have thought that they can't pick up their cell phone during working hours to go tell on us, right? Because we have a provision in the handbook that says, in fact, yeah, you can. So again, so important not only to have these types of provisions, but properly worded provisions, because they can be landmines for us if they're not drafted properly. Okay. Just for time purposes, kind of go through this because this is really more for lawyers who draft these types of agreements, on your behalf, but I'm letting you know. So another aspect of the amendment says that we cannot enter into any agreements, clauses, covenants, or waivers that are unilateral conditions of employment. In other words, take it or leave it employee, that requires the employee to waive, arbitrate, or otherwise diminish any existing or future claim or right or benefit to an unlawful employment practice they have against us, if that provision has the purpose or effect of, for example, shortening applicable statute of limitations of Illinois laws, applying a non-Illinois law to an Illinois employee's claim, or requiring the employee to adjudicate, which is a fancy word for litigate, that claim outside of Illinois. So let me give you an example of this. We'll talk about later on how the Illinois Human Rights Act was amended in January 1st, 2025 to enhance the time period that employees had to file a charge of discrimination against us with the Illinois Department of Human Rights. Prior to January 1st, 2025, they had 300 days from the date of the alleged violation. Now, since January 1, 2025, they have 2 years, right? So let's say, for example, that we draft a provision in let's say an employment agreement that says that you agree that you will not file a charge of discrimination. You only have 300 days. And this is a crazy example, but it just puts it in context, that you only have 300 days to file a charge of discrimination with the Illinois Department of Human Rights related to any violations under the Illinois Human Rights Act, right? So in fact, that provision has the effect of shortening that now 2-year statute of limitations to what it was before, 300 days, right? That would be void and a violation of a matter of public policy. That's an example of something like that. Again, this is more for, first of all, you shouldn't be drafting these things. It should be employers drafting these types of agreements. So hopefully to the extent you are using, in-house or outside lawyers, they're aware of these changes. Another amendment to the Illinois Workplace Transparency Act. This is an existing provision in there, and it adds to the existing provision. So we may, so for example, remember earlier when I said there are some exceptions to when we can require an employee to keep their mouth shut and not air our dirty laundry? Well, this is one of them. If the employee agrees, and we include this provision, let's say, for example, in a separation agreement, right? So we terminate an employee, we have them sign a separation agreement because we're giving them severance, because we don't want them to sue us. And in that separation agreement, I will include this language in there for instances or cases of, where there may be, for example, a fear of an employee airing our dirty laundry if they think there's a sexual harassment claim or something like that. And so by including this language in there and having the employee acknowledge it and essentially allotting money to this, part of that severance payment goes to this, that in fact can keep the employee's mouth shut. Again, they have to agree to it. We have to, let's say you're given $10,000 in severance. Generally what I do is say, of that 10,000, we're only going to give you 5, and then 5 is going to be for your acknowledgement agreement to basically keep your mouth shut after you leave. Again, high level legal stuff, but I want you to be aware of this because this particular language is being amended now. So to the extent you had lawyers who included this language in separation agreements, they need to know about these amendments. Okay. Finally, the last bit for the Workplace Transparency Act, a lot going with this law, is that to the extent that we create and draft a contract or agreement that is in violation of the act, and the employee sues us, or we sue the employee and we lose, right? We say you're violating the confidentiality provision, and we lose. Now the employee can recover a new bucket of damages. And that new bucket of damages is called consequential damages. And what that means are damages that are a resulting consequence of the employee having to, for example, defend against a claim or file that lawsuit. So let's say, for example, the employee, they're generally talking about former employees, they say, well, I needed to take off a week's time of work that I had to do unpaid in order to go to court or go to a deposition. They win. Guess who's paying them their wages for that time period? If you said me, the employer, you would be right. That's that category of consequential damages. So again, something to be very careful about, and why it is so important that when we draft these types of agreements, clauses, that we're doing so properly. Because if not, there are damages, there are repercussions to that. Okay. New law. This law went into effect August 14th, 2025. I'm going to give you a very kind of high-level overview of it because it's nothing we need to do, but it is something that will happen if something else happens, right? So let me be a lot more clear about that. This new law is called you don't need to put anything in the employee handbook for this. This is more FYI, I just need to be aware about it. It's called the Workers' Rights and Workers' Safety Act. It went into effect August 14, 2025. The whole impetus and reason why this act came into place is because a certain political party was worried that when another political party took office, they were going to roll back certain protections for employees. Well, that didn't happen. Regardless, this law took effect. And what this law says is if that political party, anytime during the term, while they're in office, roll back certain protections afforded to employees under the Fair Labor Standards Act, under the Federal Occupation Safety and Health Act, or under the Federal Coal Mine Health and Safety Act, and if they roll back any protections that existed as of April 20th, 2025, and they take those protections away, then the Illinois Department of Labor is required to step in and basically create legislation to resurrect those protections. That's what this law is. So let me give you an example. Recently, the OSHA issued a proposed regulation that if it came to fruition, which I don't know if it will or not, it's proposed right now. I think it's in a comment period. But the proposed regulation would exclude from the protection of the general duty clause under OSHA. It would exclude protections that have otherwise been afforded to employees who engage in inherently risky professional activities from the scope of the general duty clause. In other words, if this regulation goes into effect, a whole category of employees here in Illinois who otherwise would be protected under the OSHA Act, and otherwise their employers would be required to make sure their workplaces are free from potential hazards. If this regulation takes effect, those employers basically can turn a blind eye to anything they think hazards in the workplace, because these employees will no longer be protected. Certain employees, again, they engage in inherently risky professional activities. Let's assume that regulation actually takes effect sometime down the line. If that were to happen, then the Illinois Department of Labor would be required to step in and say, well, not here in Illinois. Employees, all Illinois employees, all Illinois are protected under the general duty clause of the OSHA Act. We are not excluding anybody. And they'd be able to do this even though here in Illinois, the Illinois Department of Labor only has jurisdiction over public sector. They don't have jurisdiction over us as private sector. OSHA, that is, OSHA. They don't have jurisdiction over private sector OSHA violations. Only federal OSHA does. But under this law, Illinois Department of Labor, despite them only having jurisdiction over public sector OSHA, would have to step in and say, no, every worker still has that protection, right? So that would be an example of when this law would ever actually have any relevance. An amendment to the Family and Military Leave Act. This also took effect on August 1st, 2025. It updates and expands the Family and Military Leave Act. So the Family and Military Leave Act that applies to any Illinois employers with 51 or more employees. So again, if you've never heard of it, and that's because you have less than 51 employees, it's probably why. If you have more than 51 or more employees, this should be a policy in your employee handbook. And know that the name is now changed. It is no longer the Family Military Leave Act. It is the Military Leave Act. So they've gotten rid of the preface of family. Now it is the Military Leave Act. In addition to that, it adds new provisions to the Military Leave Act that provide for paid leave for any employees who undertake military funeral honors. So what do we mean by that? Well, first, again, just to be clear, this whole act applies only if you have 51 or more employees. And why is that relevant? Because you then are subject to FMLA. And you'll see here with the fourth bullet point down, in order for an employee to be eligible for paid leave under this Family Military Leave Act for military funeral and honors, they must be eligible for FMLA. In other words, they must have worked for 12 months and worked at least 1,250 hours during that 12-month period. If, in fact, they meet that criteria, then for qualifying employees, they're entitled to use up to 8 hours of paid leave that you are providing them. This isn't leave that we require, say, hey, well, we're giving you 40 hours of the paid leave for our workers, Zach, so you have to use that leave first. No. This is paid leave. We are paying the employee for that, separate and apart from company-provided paid leave. They get to use 8 hours of paid leave per calendar month with a maximum of 40 hours per year to participate in military funeral honors, military funeral honor details. Now, to qualify for this, the employee must be trained to serve in funeral honor detail of a veteran, and the employee is either an active or retired member of the U.S. Armed Forces or Reserve, including the Illinois National Guard, and must provide that funeral honor details visa an authorized provider of such services. So, this may never apply to you if you have 51 or more employees, because you may never have an employee who is trained in military funeral honors, but you never know. An employee who takes this type of leave does so in lieu of, again, as we talked about, without having to exhaust their existing company provided paid leave, right? So again, you cannot require them to take paid leave. The company provided paid leave. This is, again, separate and apart from that. You are paying them for that. The employee must give you reasonable notice. We are required to request confirmation that you, in fact, are doing this, right? Because it's 8 hours up to 40 hours of paid leave. So make sure you provide it to the extent you have any employees that they're subject to this, that you in fact require. In other words, when you draft your policy, that you require that they give you advance notice and that they provide you with confirmation they in fact were doing this when they said they were doing it. They're going to be paid at their regular rate of pay for any hours used. Leave is job protected, right? So when they come back, whatever position they were in, that's the position they're coming back to. Unless you're an independent living facility, you cannot deny an employee's request to use that leave. Okay. An amendment to the Wage Payment and Collection Act. This also took effect August 1st, 2025. So it's already in existence. And I can go through this pretty quickly for you in terms of what it did. To the extent that a complaint was filed against you at the Illinois Department of Labor, to the extent that you underwent, there was an administrative hearing, right, at the Illinois Department of Labor with an administrative law judge, and you lost. And the administrative law judge said you owe Scott $5,000 in back pay, right? That order as to you owing me X amount of money in back pay, under this law, it automatically becomes a debt to the state a lot quicker. And the reason is because the Illinois Department of Labor, from what I was told, had to go through kind of hoops and ladders to get that to become a debt and ultimately get employers to pay. Now they don't have to. There's after, for example, 35 days, if you don't appeal that administrative law judge decision, let's say to the circuit court in the local county, automatically becomes a debt to the state, which means the state can then come after you immediately and say, where's our money? And start levying fines and other things against you for failing to pay. That's what this amendment is. In other words, it makes decisions from the Illinois Department of Labor following administrative hearings debts a lot quicker, so the state can come after you a lot quicker to collect those debts. Okay. Amendment to the Illinois Equal Pay Act. Again, this took effect June 30, 2025. If you have 100 or more employees, then or hopefully should know that you're required to obtain a equal pay registration certificate from the Illinois Department of Labor every 2 years. This amendment does not change that. You're still required to do it. It just changes who, in fact, is required to get that certificate. But all of you, if you have 100 or more employees, remember, you always, every 2 years, you have to recertify for that. Okay. An amendment to the Illinois Human Rights Act. Another amendment to the Illinois Human Rights Act. It will take effect January 1st, 2026. Two parts of the amendment. The first part is this. Whenever an employee goes to the Illinois Department of Human Rights, files a charge of discrimination against us, they need to do that to get the ball rolling. After they file that charge of discrimination, after a certain period of time, after we file the position statement in response to the charge, then as of right now, the Illinois Department of Human Rights always required us as employers and the employee to attend what's called a fact-finding conference. We always had to do that. It was just a conference with the investigator, us as the employer, and the former employee. Come January 1st, 2026, the Illinois Department of Human Rights has the discretion as to whether they're going to do that. So the language is going to be in lieu of, and that's going to say shall anymore. It's going to say they may undertake a fact-finding conference. That's it. So it goes from they're always going to do it to, well, we'll let you know if we're going to do it or not. However, to the extent you and the former employee actually want it, and there are some strategic reasons why we as employers say, you know what, we want that, then both you and the employee must submit a request to the IDHR, and they have to grant that. The second part of the amendment, there's new civil penalties. And this could be a potential game changer. A game changer in the sense that right now it is very infrequent and rare. Once an employee goes through the proceedings at the Illinois Department of Human Rights, it is, and let's say they get that what's called a notice of right to sue letter, it is very rare that the employee and the employee's attorney will then file a complaint with the Illinois Human Rights Commission. Nobody wants that. They don't, even employees and their lawyers don't want to do that. And there's a lot of reasons why they don't want to do that. Instead, they'll sue us in state court if they choose to sue us. Now, employees and their attorneys may say, you know what? We may now want to actually file a complaint against our former employer with the Illinois Human Rights Commission. And the reason is because there's some more teeth to it if they win. And that teeth is now these civil penalties that the employees can recover if the administrative law judge at that administrative hearing finds that we violated the Illinois Human Rights Act. And if they do so, come January 1st, 2026, then we can be imposed a penalty on top of paying that former employee's attorney's fees, on top of paying back pay, with a penalty of up to $16,000 if it's our first violation. If we're repeat offenders and had one prior violation within the last 5 years, then we can pay a penalty of up to $42,500. And it goes increasingly higher and higher if we are repeat offenders. And so to me, as a practitioner for the past now 24 years, I look at this and say, well, this could be a game changer because I don't want to be in front of the Illinois Human Rights Commission. It's like the wild, wild west there. I may not have a choice anymore, I and you, because the employee may say, you know what, we want to go in front of the Illinois Human Rights Commission because now there's these penalties there. So, to be determined as to what the plaintiff's bar is going to do. But we'll wait and see. All right. Proposed amendments to a law called the Right to Privacy in the Workplace Act. As of today, I don't believe Governor Pritzker has signed these amendments into law, but he will. He will. These amendments relate to, so let me take a step back. This Illinois Right to Privacy in the Workplace Act was amended on January 1st, 2025. And the amendments related to our use, to the extent you did use, E-Verify, right? So when we hire new employees, instead of doing kind of old school, we would submit the information through E-Verify, and it would, let us know whether or not that employee was authorized to work in the U.S. And the amendments in January 1st, 2025 apply to our use of E-Verify. And in essence, and I've drafted articles on this, imposed on us new obligations to provide written notification to employees if the E-Verify came back and said, may not be authorized to work in the U.S. The amendments now, even though they're still in effect and took effect January 1, 2025, the Illinois Department of Labor said, you know what, we're going to expand the scope of this. And it's no longer going to apply just to use of E-Verify because many employers don't use E-Verify. So come January 1, whenever Governor Pritzker signs this, under the Illinois Right to Privacy in the Workplace Act, all the references to E-Verify you will see will be gone. And the amendments state that if an employer receives a written notification from any federal agency, i.e. the IRS, i.e. or for example, the Social Security Administration, or other outside vendor not responsible for the enforcement of immigration law. So for example, right, let's say you use an outside payroll company like ADP, and they file for your 1095C, your Form 1095C forms. And upon filing it, ADP sends you a notice back that says, hey, we just got notice, right, because we filed it on your behalf from the Social Security Administration or IRS, I forget which one, that these following people, their social security number doesn't match with what SSA has. If that happens, whether or not you use the verifier or not, right? You get written notification. In other words, no match letters. No match letters. And under this current administration, we can see an uptick in no match letters happening. Under the prior administration, they basically turned a blind eye to it. Under this administration, obviously that's not happening. If we get that no match letter, then there will be, because again, we're waiting on the governor to sign this, but again, he will. There are similar, if not identical, obligations to us that we will be required to undertake, like the amendments that took effect a year ago. So they basically kind of just cut and paste those again, and they said, yeah, you're already doing this, you're going to continue doing this. Again, they're just taking away the reference to E-Verify. Now it's just, if you get any written notice. And so here are those obligations. One thing to keep in mind is what I put in bold here. And it's problematic for me as an employment lawyer, and I'll tell you why. It states that, and this is in the current version of the Illinois Right to Privacy in the Workplace Act already, and I had issues with it that I talked about with the Illinois Department of Labor. And it's still in there now. That the employer must not take any adverse action against the employee solely based on the receipt of that notification, right? So in other words, it says, if you get that no match letter, you can say, well, Scott, we don't know what the hell's going on here, but we got this no match letter, and you know what? We don't want to deal with it. You're fired, right? Can't do that, really never could do that. My concern here, though, is that if, for example, we say, hey, Scott, got this no match letter. We're not sure what's going on. It appears to say, though, that your Social Security number does not match with what Social Security Administration has on file for that name. Now, we don't know. Could be any reason. We don't know what's going on here. And then we ask the question, do you know what's going on here? Do you know why we may have, why the Social Security Administration is sending us this? And if I respond and say, well, employer, it's because that Social Security number is a fake one. I gave you a fake Social Security number at when I commenced employment here. It's a big deal. It's a big deal because under a federal law called the Immigration Reform and Control Act, that law says once we have actual knowledge that the employee is not authorized to work in the U.S., and once I tell you that my Social Security number that I gave you is fake, you now have actual knowledge that I am not authorized to work in the U.S. And the Immigration Reform and Control Act says you have to fire me on the spot. Have to fire me on the spot. So, we need to be very careful if in fact that situation arises. One, first, reach out to a competent employment lawyer to get advice, but ultimately, you need to be careful with how you are documenting that separation of employment, because this law says you can't take any adverse action based solely on your receipt of that no match letter. My response would be, we didn't. We took adverse action, in other words, terminated, because the employee admitted to us that the Social Security number they gave us is false. It's fake. And the Immigration Reform and Control Act says we now have to terminate it. Had nothing to do with our receipt of this, because we don't know what was going on. We, in fact, had the conversation, said, we don't know what was going on. We asked the employee, do you know what was going on? And the employee admitted to us. That's how you have to navigate that. And you got to be very careful in terms of how you're documenting that and navigating that because of this language in here. All right. That's 2026. Let's put the crystal ball away. Let's take the rearview mirror. Let's see what's been happening for the past year. Hopefully you've all been compliant. Pay scales, disclosure of pay scales and job postings, right? That took effect January 1, 2025. It requires Illinois employees with 15 or more employees to make sure that any job postings that they create, internal or external, that they have certain information in them. This, first of all, would not apply. I get questions about, what if we just put a help wanted sign up that says help wanted, but doesn't say a particular position? No, because that's not a job description, right? You're just saying help wanted. You're not saying for what job. If you say help wanted, looking to hire cashiers, well, then that would be a job posting. What about when you send out a company-wide email, right? And say, we are looking, everybody, just so you know, we're looking to hire a new HR director. If you know anybody, let us know. Well, that is a company-wide email in which you are seeking information or candidates about a particular position. So yes, that would apply. That would be considered a job posting. What if you just post a sign in a break room encouraging employees to apply for any promotional opportunities available, but you don't say what those are? That likely would not qualify as a specific job posting. So it's when you have a job posting that is seeking candidates for a specific position, then the requirements under the Equal Pay Act as to relate to what we're going to talk about here apply. What are those requirements? We have to provide the pay scale and benefits in the specific job posting. So it's either the wage, right, hourly salary or range of salary, or the range, right? So $20 an hour to $30 an hour, $50,000 to $70,000, that you expect to pay the person who is successful in applying for that particular position. And you are also required to provide a general description of the benefits and compensation that you expect to provide that employee if that individual, if they are successful in applying for that position, right? So one thing to keep in mind here, be careful how you're drafting these things. So for example, I have bonuses here in italics. The reason is because you could, for example, in a job description state, employee will be, this position will provide the following: year-end bonuses, period. Not period, semicolon, blah, 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 blah. A savvy employee and their lawyer may, in fact, use that against you. If, in fact, you terminate someone and don't give them a year-end bonus, because they're going to use that job description and say, well, hold on, employer. In your job description, you said this position is entitled to year-end bonuses. I didn't get a year-end bonus. Well, you didn't last the year. Doesn't matter. You didn't say discretionary. You didn't say in here that I had to be, So you've got to be very careful on how you're drafting these things to not give the impression, right? And bonus, I think, is a good thing, right? If they are discretionary bonuses, the employee may, if eligible, receive bonuses, right? Then there can't be any expectation that they're in fact going to get it. The pay range should be from the lowest you expect to the highest for that position, right? So if you're seeking a HR director with between 2 and 5 years of experience, how much do you expect to pay someone with between 2 and 5 years of experience, right? What are you going to pay? That's the range. What are the benefits someone with between 2 and 5 years of experience would otherwise expect to get for that position? That's what you have to put in the job description. Per the Illinois Department of Labor, they said a range's bottom and top should not include open-ended phrases like 40,000 and up or up to 60,000. It's got to include a bottom and a top, right? Phrases such as pay starting at 50,000, depending on experience, that's too vague. It's got to have a bottom and a top. We do not need to include the nature of the benefits. We do not have to provide, While we must describe the nature of the benefits, we do not, as of yet, I say yet because it could be subject to change, provide specific details, right? So for example, paid leave, you're all subject to the Paid Leave for All Workers Act. We don't need to say employee will get 80 hours of paid leave, and in year 2, 100, all you say is paid leave, 401k, health insurance, dental insurance. We don't have to associate a numerical value to that, right? All you're saying is the nature of the benefit, paid leave, 401k, health insurance, that's what you have to do. For the benefits, you could include a hyperlink to, let's say, your website, your web page, that if I go click on there and click on that web page, that link, it'll show me the benefits that I could expect to get for the particular position in question for which I'm applying. Also remember, and I get this question a lot, Scott, does this law require us to create a job posting? And the answer is no. It does not require you to make a job posting. It just says if you do, then you have to comply, right? So for example, you may say, someone, say, the HR director may be retiring, and the HR director may say, you know what, I know someone who would be perfect for me when I leave. And you say, oh, great, we'll interview them. You don't need a job posting because your current HR director is feeding you candidates, right? And if that's the case, then what the law says is that if no job posting has been made available, then you need to disclose to the applicant the pay scale and the benefits that you intend to offer for that position prior to that applicant bringing it up. So it's like, hi, my name's Scott Cruz. I'm here to apply for this position, right? It almost is like you have to tell me, okay, Scott, I know we didn't have a job posting, but this is what we're going to pay for. We're intending to pay for the position. This is what we intend to provide in terms of benefits, right? Because there is no job posting. That's how that discussion needs to happen. Remember that it applies not only to positions that are being physically performed in Illinois, 100%, but positions that may physically be performed at least in part in Illinois, or positions performed outside of Illinois, but the employer reports to a supervisor whose office or worksite is in Illinois, right? So if you're looking, for example, for someone in IT, and you cast a wide net, you're not just looking in Illinois, right? It could be from anywhere because the person can work remotely from outside of Illinois. That job description, right, would need to comply with the requirements that we just talked about. If, for example, that employee, and likely so, their supervisor works in your office in Bloomington, right? If that's the case, then that job description would have to meet the requirements of the pay scale and the benefits. If you first make the opportunity available externally, right? So you put it on, let's say, Indeed or some other job posting, job site. You've got 14 calendar days to make that position available internally, right? So if you post it on Indeed today, you've got 14 calendar days, with tomorrow being day one, to post that internally. So I get a lot, well, hey, the reason we're posting externally is because, we haven't told the employee yet we're going to fire them. So we don't want them looking and saying, oh, it looks like you're looking for my position. Why? What do we do about that? And the answer is there isn't anything, because the law says if you post externally, then you've got 14 days to post internally. So, be very mindful of that. If you're posting externally first for all opportunities, not just for promotion, because I asked the Illinois Department of Labor about that. I said, only opportunities for promotion? And they said, no, any job posting. Any job posting externally within 14 days has to be posted externally. All right. An amendment to the Illinois Human Rights Act that added a new protected class that took effect January 1, 2025. That new protected class is something called family responsibilities. What it says is that we cannot it makes it unlawful for us as an employer to make any employment decisions that would discriminate, harass, or otherwise retaliate against someone based on their actual or perceived family responsibilities. So how is family responsibility? So hopefully you added this to your employee handbook. How are family responsibilities defined? It means an employee's actual or perceived provision of personal care to a family member. What does personal care mean? Very similar to those of you subject to FMLA. If an employee needs to take leave, FMLA leave, to care for a family member, an immediate family member. But this means activities not identical, but similar. So personal care means activities to ensure that a covered family member's basic medical, hygiene, nutritional, or safety needs are met, to provide transportation and medical appointments for a covered family member who's unable to meet those needs, him or herself. It also means being physically present and provide emotional support to a covered family member with a serious health condition who's receiving inpatient or home care. And here's the definition of covered family member. Now, this sounds like a big Pandora's box. And you may be wondering, oh my gosh, how can I ever deny such a thing? Well, you can. And let's talk about that. Now, before I talk about that, the hypothetical I'm going to use and how I've been seeing this in practice is an employee who just started with you, right? Let's assume you're subject to FMLA. And even if you're not, it's same thing. Different. Let's assume you're subject to FMLA, right? You have 50 or more employees. And the employee interviews and they get the job. And on day one, they say, oh, you know what? Forgot to tell you. I'm mom's caregiver. Dad passed away. No other family members around. Mom needs to go to doctor's appointments for physical therapy every Monday, Wednesday, Friday, from 10 to 11. And then I've got to drive mom back to her home. And the only closest physical therapy place is, 30 minutes away. So every Monday and Wednesday, Friday, basically, I'm going to work from home in the morning, or can you advance me paid leave for the time period that I'm going to miss? And you say, whoa, what? What are you talking about? How do we address that? So the act says that nothing in this act is construed to obligate us as an employer to make accommodations or modifications to reasonable workplace rules or policies for an employee based on family responsibilities, including accommodations or modifications relating to leave, workplace scheduling, productivity, attendance, absenteeism, timeliness, work performance, so long as those rules or policies are applied in accordance with this act. In other words, if you have existing and well-drafted policies in place, and if that employee's request would require you to modify or make accommodations to that existing policy for this employee based on family responsibilities, the law says we don't have to do that. Now, in my hypothetical, the employee was not yet eligible for FMLA. If this is a current employee who's been with us for 5 years and they're eligible for FMLA, FMLA governs. This doesn't even come into effect, right? They're going to get it. In my hypothetical, the care for mom, that's FMLA. I get it. I'm going to get it, right? This doesn't come into play. If you're not subject to FMLA, or if the employee yet is not eligible for FMLA, that's when this comes into effect. And that's what I've been seeing here, right? So using my hypothetical, what policies are triggered that potentially the employee is asking us to make a modification or accommodation for? Let's say it's an hourly employee. Let's say that, and the employee can't work from home. Their position does not allow them to work, or say, hey, you can't do your essential function of your job from home. Let's say you've got a policy in place that says, even if you could, we've got a no remote work policy in place. We also have a policy that says we don't advance paid leave, ever. We also have our paid leave policy that says you're not even eligible to use paid leave for 90 days, right? let's say that we also have a policy that says if you're not using protected leave, any absences, you're going to be subject to our discipline policy, right? And points policy. Well, all of those policies are potentially implicated using my hypothetical, right? The employee says, I want to work from home. And we say, well, we got a policy that says, one, we don't allow that, right? And two, your position doesn't even permit that. The employee says, well, I want you to advance me paid leave. And we say, well, we've got an existing policy that says we don't do that. And our existing paid leave policy also says you're not entitled to any paid leave, even though you begin accruing it on day one. Not only do we not advance it, but you're not entitled to that, to use it until you've been with us for 90 days. And you're asking us to make a modification for that. And you're also asking us now to say, hey, if I'm just not at work, don't ding me for that. But we have a policy that says if you're not using protected leave, we are going to ding you for that, right? So because of that, unfortunately, we're going to deny your request. Now, again, my hypothetical assumes you have these well-drafted policies in place, right? That is the genesis of my hypothetical, because we're using those policies to say, hey, we don't make exceptions based on family responsibilities. Now, it says we can't discriminate, right? So what if, for example, and this is where my hypothetical can be negated, if you already permit employees to work from home remotely for family responsibilities, because little Johnny's only 2 and there's no daycare. And the person you allow to do that looks a lot different than the person who's asking you to making this request, right? So you need to take a big, broader view of, okay, have we done this in the past? And if so, have we permitted these things for family responsibilities? And if you have, and the two people don't look alike, well, that's when we get subject to discrimination claims, right? So again, I took time to go through this example for you so you understand how to navigate these. But at the end of the day, you have to look and say, what have we been doing already, right? What have we been doing already, comma, for family responsibilities? All right. New protected class as of January 1, reproductive health decisions, speaks for itself. The Illinois Human Rights Act was already amended. I talked about this earlier, that permits employees to file a charge of discrimination against us prior to January 1, 2025. They had only 300 days from the date of the alleged act. Since January 1, 2025, they now have 2 years. And that only is to go to the Illinois Department of Human Rights and file a charge of discrimination against us. It does not expand the time period for the employee to file a charge with the EEOC, but who cares, because they have 2 years to file a charge against us with the Illinois Department of Human Rights. Amendment to the Illinois Wage Payment and Collection Act. These amendments went into effect January 1, 2025. The genesis of the amendments relate almost entirely to pay stubs. Who would have thought pay stubs were so important that there had to be an entire amendment that's multifaceted regarding pay stubs? And the answer would be, well, the Illinois Department of Labor did. That's why that's why these amendments are in place. So, what are the amendments that have been in effect since January 1, 2025? There's now a definition of pay stubs and what information we're required to include on pay stubs. Now, you may look at this and say, we're already doing that, Scott. What's the big deal here? Well, the big deal is what I put in bold, hours worked. And you may be saying to yourself, again, enlighten me here, because we have hours worked on our pay stubs. And I would say for all of your employees, and you're likely going to say, yeah, for our hourly employees. And then I'm going to reply and say, that's not what I said. I asked for all of your employees, meaning your salaried exempt employees. And you're going to say, well, no, we don't keep track of our salary exempt employee hours. And I would say, why not? Because since 2014, every single employer in Illinois has been required to. And that's why we need to include hours worked of all our employees on our pay stubs. That means salaried exempt, not just hourly non-exempt. It means all employees. There was an amendment in 2014, the Illinois Wage Payment and Collection Act, that required us to have daily time records for all of our employees. It says regardless of classification. So we need to know Monday, Tuesday, Wednesday, Thursday, Friday, how many hours did Scott work on those days? In 2018, the Illinois minimum wage law was amended that also included the same thing, that employers are required to have daily time records for all employees, regardless of classification. That means your salaried exempt employees. So when you tell me, Scott, we don't keep track of their hours, so we don't put it on our paycheck, I would again respond and say, why not? Because you're in violation of not only the Illinois Wage Payment and Collection Act, the Illinois minimum wage law. All of you on this webinar are subject to the Paid Leave for All Workers Act. Guess what that law says as well? You're required to keep hours and maintain hours for all your employees. How come you're not doing so? How come you're not doing so? Now, I don't know if any of you are in fact not doing so, but again, I'm not seeing you in person. So hours worked, that's why that's on there. We're required to maintain copies of pay stubs for not less than 3 years after the date of payment, not from when the employee leaves. 3 years from the date of payment. Now, keep in mind that the Illinois Equal Pay Act says, well, you got to keep payroll records for at least 5 years. So what does that mean? You go with 5 years, not the 3, 5. Guess what agency is in charge of enforcing both the Illinois Equal Pay Act and the Illinois Wage Payment and Collection Act? We said the Illinois Department of Labor. You get the gold star today. So ultimately, even though this has 3 years, another law that the same agency is in charge of enforcing says 5 years, so we do it for 5 years. We're required to provide copies of pay stubs to our employees upon request, or former employees. If they make that request, they have 21 calendar days, or not they, you have 21 calendar days to provide pay stubs. Now, understand also that there's a law called the Personnel Record Review Act. And under that law, we've got 7 business days to respond to a request for certain personnel records, which would include pay stubs. So if the employee tells you, I want my pay stubs, you need to ask the employee, are you making that request under the Personnel Record Review Act, or are you making that request under the Illinois Wage Payment and Collection Act? Again, the reason is Wage Payment and Collection Act says we have 21 calendar days to provide them to you. Personnel Record Review Act says we've got 7. So very important distinction here. You don't have to comply with that request for the pay stubs, at least under this act, for more than twice. They can make the request twice in a 12-month period. Former employees, after a year, we can tell them to go pound sand. In addition, for all of you who, and it's probably all of you, who use direct deposit for providing pay stubs to employees. If, for example, you use, let's say, I don't know, a third-party payroll provider, let's say Paylocity. The question here is, when it's my last day of employment, can I still log on to my account in Paylocity to review my pay stubs for at least a year after separation for the preceding year, right? In other words, let's say today's my last day. Tomorrow, when I'm no longer your employee, can I still log on to my Paylocity account? And will I have access to that Paylocity account for at least a year? And when I log on, do I have access to my pay stubs for the 12 months preceding my date of separation? If the answer to that question is yes, you do not have to comply with what I'm going to say next. If the answer to the question is no, that your access ends on your last day of employment, listen up. And we've had to do this since January 1, 2025. We must make an offer to the employee by the end of the final pay period, whenever that final pay period is. Ask the employee, Scott, do you want us to provide you with a copy of your pay stubs for the 12 months preceding separation? You're required to document my answer. Put that in writing and keep that in your files. If I say yes, then you must provide me with a copy of my pay stubs for the 12 months preceding my separation date. If I say no, then you don't have to. How many of you have been doing this? Again, I'm not in person, so I don't know. If you haven't, know what the penalty is if you get caught. It's $500 per violation. So if you've terminated 30 employees and their access to Paylocity was cut off day of separation, do 500 times 30 and then get a checkbook out, and that's what you're going to have to pay, right? If you get caught. It's a big deal. It is a big deal. So make sure you've been complying with this if it applies to you. Personal Record Review Act, that law I just talked about, that also was amended. I'll go kind of quickly here. We don't have much time left. It changes the manner in which employees are required to request their personnel records. And the second bullet point here, make sure you're including this in your handbook under the section, which I know all of you have, that said if you're requesting personnel records, this is what you must do. This is what they must do now. And you, if they don't follow this, you can say no. They can say no. If they're requiring or requesting medical information, since January 1, 2020, we can require them to provide us with a HIPAA compliant release. And if they don't do that at the time of the request, we don't have to provide them that medical information. Or maybe they want the workers' comp file, right, as part of this Personal Record Review Act. Well, we need a HIPAA release. It also changes the category of documents that we're required to provide them when they make the request. So generally what you're going to see is the employee is going to say, we're going to get a request that says, please provide me with all of my personnel records to which I am entitled to under the Personnel Record Review Act. One, if you get that request, know that the person's talking to a lawyer, because only lawyers talk like that. And if that's the case, and even if the employee just says, hey, I want to see my personnel file, period, right? One or the other. We're required to, have always been required to give them all of the categories of documents here since January 1, 2025, also related to benefits. So any health insurance, dental insurance, vision insurance, any benefits, any documents related to their benefits, they get. They don't have to tell us which ones they want. We are required to provide them with all applicable categories. Now, generally what I do is I will, write an email for my clients, and we're going to respond back and say, to be clear, please identify which category of documents you are requesting under the Personnel Record Review Act, right? Because they may say, well, I only need documents relating to my discharge. Okay, well, that's all we're going to give you then. But if you don't make that request and don't get clarification, you got to give everything. You have to give everything because that's what the law requires. So January 1, 2025, that includes benefits. We're also now, since January 1, 2025, required, even without the employee asking, any contracts or agreements, right? Any employment agreements, any non-compete, non-solicitation, confidentiality agreements. If those are there, they get them without even asking. Any employee handbooks that were made available to the employee that the employee acknowledged receiving, they get them. They don't even have to ask for it. If you don't have an employee handbook, but you have standalone policies, do any of those standalone policies relate to the reason, for example, of termination? If so, they get them. So understand, again, this has been in place since January 1, 2025. New law that took effect in August of 2024, I think it was, but essentially 2025. This was January 1, 2025, I think, yeah. But in any case, it's in effect, called Freedom of Speech Act. Very quickly, because we're running out of time here. This act addresses our requirement that employees attend mandatory employer-sponsored meetings. And it permits employees to basically say, I'm not coming. Or if they're in the meeting, to get up and leave, and there's not a damn thing you can do about it. If the purpose of that meeting is designed to communicate your position, or as part of it, it just comes up on religious or political matters. Now, you may be saying, we don't talk about religion in the workplace. We don't care about what someone's denomination is. We don't talk about politics in the workplace because we have mandatory employer meetings because we don't tell our employees who to vote for. It's good, you shouldn't. But look how the definition of political matters, how that's defined. And you can thank our friends, organized labor, for this, because it's the only reason this law was put into effect. Political matters, in addition to what the common sense definition is, right, we all know it to be, also means anything related to an employee's decision to join or support a union. How is a union a political matter? Well, it is. So, for example, mandatory employee meeting, right? We learned that local, 3W5 of the Teamsters is looking to organize our employees, and we say no, we don't want that. So we say tomorrow, mandatory meeting, everybody has to come 8 a.m. and we don't say what it's about. Everybody comes at 8 a.m. We have 60 employees there, and we say, listen, we've learned through the grapevine that local blah, 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 the Teamsters is looking to organize, and we want to inform everybody what our position is on unions. We want to tell you why it's not a good reason to join a union. And of the 60 employees, 50 of them get up and walk out of the room. And you say, where are you going? You can't. This is a mandatory meeting. If you guys walk out, you're not going to have a job. And you end up firing the employees who walked out. Guess who's in big trouble? That would be you. Because it's a mandatory meeting, and the meeting was designed to communicate your position about a political matter, i.e. your view on organizing and unions. It could also be, though, not necessarily a mandatory meeting, but let's say, for example, a supervisor on the plant floor calls over 3 employees and says, hey, Bob, Jody, and Joe, can you come over here for a second? And they get off the line and they come over, and the supervisor says, hey, I heard that you guys were at the local BW3 over the weekend, and that you guys are the 3 employees who are looking to organize everybody here. Let me just tell you that I just came from an employer, right, who was organized, and let me tell you why you don't want to do that. This isn't a mandatory meeting, but it is us requesting that an employee to listen to our opinion about a political matter. And the 3 employees say, yeah, we don't care. Save it for somebody else. And they walk away. And the supervisor says, hey, don't walk away from me. That's insubordination. And they say, write us up. Go ahead. And the supervisor does. Guess who's in trouble? You, the employer, are. So this is very important to understand. If it's not a mandatory meeting, right, then employees don't have to show up. So it doesn't matter. They get up and leave, so what? It's never mandatory to begin with. But if it's mandatory, or if it's just our supervisor on the plant floor calling employees over to talk about these things, understand what you can and can't do. We went over what the requirements under the Right to Privacy in the Workplace Act are. These relate to E-Verify, which is currently in place. And again, remember what I said, there's new amendments on Governor Pritzker's desk relating to this exact same thing, except what they did was take out any reference to E-Verify and say any type of time you get a notice, right? So we've already gone through that, so we're not going to go through it now because it's just duplicative. There were amendments to the Illinois Whistleblower Act, and I know we're over time here, but we were 10 minutes late, so I'll take another 10 minutes here for those who can stay on. What I want everybody to know about this, so the Illinois Whistleblower Act is a law here in Illinois that says if you retaliate against an employee for ratting on you, you're going to get in trouble. And there were amendments, very important amendments, that took effect January 1, 2025, in terms of how an employer is defined. And since January 1, 2025, an employer is defined as a business, right? The actual business, or any person acting within the scope of his or her authority on behalf of the business in dealing with its employees. Well, that probably sounds a lot like if you're in HR, right? You're what does HR do? Or if you're wearing the HR hat, you're acting within the scope of your authority on behalf of the employer in dealing with employees. And why is that a big deal now? It's a big deal now because if, for example, we get a complaint is lodged against us for violation of the Illinois Whistleblower Act, and it is deemed that the employer, right, violated the Illinois Whistleblower Act, there are now criminal sanctions, not just civil damages, criminal sanctions that you could be subject to a Class A misdemeanor if you are the person who facilitated, or at least a jury thought so, facilitated that violation of the Whistleblower Act, because you are a person acting within the scope of your authority on behalf of the company in dealing with employees. So that is why that's a big deal now, right? Because that definition of employer has been expanded to potentially include you. You'll get the slides here. Anything else? Okay. So that covers what I wanted to talk about today. Here is my contact information. To the extent anyone has questions about content on the slides, I'm happy to answer that. To the extent, if you reach out to me later on. If you have questions about, hey, this is going on in our workplace, and email me and say, can you answer this question for me? I'm happy to do so if you pay for that, because of course that's legal advice, right? So with that being said, now is your opportunity to ask any questions that you have, even if it potentially means something going on in your workplace. And I will try to answer that. Let me see if I could see if there are any questions here. And nobody can see this only because it's me. Meeting info. Nope. No. Hold on a second. I don't see anything. I don't see anything. With that, if anybody does have a question, it looks like there's only 11 people left. Feel free to unmute yourself and ask. And you don't have to identify who you are if you don't want to be identified. Going once, going twice. Okay. With that, doesn't look like there are any questions. Again, you'll get a copy of these slides. Again, to the extent you have questions on content of the slides, happy to answer that. To the extent you have questions on, this is happening in our workplace, can you help us out? Obviously, that's legal advice. We need to establish a professional relationship for that. Did somebody have a question? No? Okay.
Thank you very much. Great information.
You're welcome. All right, everybody. Thanks for joining. Happy holidays.